My name is Mick Weiss. I am the owner, founder, and supervising attorney of NP Weiss Law in South Euclid and Elyria, Ohio. If you're watching this, you probably are aware Kim Davis is currently petitioning the U.S. Supreme Court to overturn Obergefell v. Hodges, which is the 2015 Supreme Court decision that determined that it was unlawful to prohibit same-sex marriages. So that meant that anyone throughout the states could get married. The states had no right to prohibit those same-sex marriages. We have a lot of people currently on the court who were on the dissent of that case, and there's now a 6-3 conservative-led split on the U.S. Supreme Court. So there is a non-zero chance that the U.S. Supreme Court could overturn Obergefell, which means that we would go right back to the way things were. Why this matters for Ohio is that Ohio still has a statute on the books that says that it is against Ohio's public policy to acknowledge or allow for same-sex marriages, whether that is in Ohio or, importantly, anywhere else in the country. The Ohio statute says we will not deem those marriages to be valid. This matters a lot if you are in a same-sex marriage or are planning to be in a same-sex marriage. In Ohio, marriage gives a lot of protections, a lot of legal protections, and a lot of legal entitlements that if they go away, the only way to get those back is through estate planning. A couple of the ways that married people are treated differently than other people, not just the recognition, but most importantly is property rights, is if one of you were to pass, a lot of the default rights in Ohio say that the spouse gets all of or most of the assets that were not planned for. There are healthcare decisions that a spouse automatically gets to make for the other just by virtue of being the spouse, without a healthcare power of attorney, without a living will, without anything else. And that goes away if Obergefell goes away. There are parental rights that can potentially go away because people are unmarried. That could only be cured with nomination of a guardianship or with an adoption. Additional, expensive, sometimes complicated steps just to get the same rights that a same-sex couple would automatically have if they were married. So while we certainly hope that Kim Davis's petition is denied and that the U.S. Supreme Court does not hear it, there's a possibility that they do hear it. And so what do you have to do as a same-sex couple to get back those rights that might be stripped from? Well, we can't help with all of them, but we can help with quite a few. The most important thing that you can do for property is to update your wills, is to assert that your spouse is the one that you want in your will to be receiving your property. They might lose the default provisions. You have to state that explicitly. To be doubly safe, establish a trust. Establish a trust that you either put your assets in directly or direct your will to put into that trust. So it goes directly outside of probate. We don't have to deal with that. We don't have to deal with the courts determining that those funds should go somewhere else. They're just held in trust for the benefit of your spouse. Designate powers of attorney, naming your spouse as your agent. This can be extremely important when you're trying to deal with money, when you're trying to deal with bank accounts, when you're trying to deal with cars, when you're trying to deal with houses. Establishing that legal, lawful power of attorney for them to act on your behalf that they lose because they're no longer your spouse, that's important. Name beneficiaries directly. Do that on your bank accounts, on your life insurance, on transfer on death designations for your house, for your car, so that we don't have to deal with probate on this, and that some other beneficiary might come in and swoop what you really do want your spouse to receive there. Consider, when you're doing those retitling, considering titling them in joint owners with rights of survivorship so that they go directly to your spouse, and prepare for advanced directives. That can include not only living wills and healthcare powers of attorney, but that can include nominations of guardianship. This is especially important if you have a child and maybe your spouse did not adopt that child, is someone that you brought in. Nominating that other person to be guardian is extremely important so that they can just pick up where you left off, because without that spousal presumption, maybe they don't get to be the guardian. Maybe it goes to someone else. So this is a non-exhaustive list of the things that you can do to try to head off some of the legal issues that might come about if King Davis is successful, if Obergefell is overturned. If you or a loved one need some assistance planning for that potential eventuality, please call our office.